Hello and welcome. This is a new court filing from the prosecution in the Massachusetts versus Karen Reed case. Today is April 4th, 2025, and this was filed today, April 4th, 2025. It reads, Commonwealth's motion in limine to admit testimony of Caro Miyasako as a substitute witness. Now comes the Commonwealth and respectfully requests that this honorable court allow Caro Miyasako, a senior DNA analyst of Bode Technologies, who personally conducted a technical review of the work of DNA analyst Tess Chart in this matter, to testify at trial. Tess Chart, the DNA analyst who conducted the mitochondrial DNA analysis and compared those to the DNA profile of the victim from the known standards in this case, is medically unavailable to travel to Massachusetts for this trial. The Commonwealth seeks to introduce the results of the profiles through the testimony of Mr. Miyasako following his technical review of Ms. Chart's work. Mr. Miyasako will give his own opinions based on his review of the testing conducted by Ms. Chart. Both individuals involved work for the Bode Technologies lab. The Commonwealth does not intend to introduce at trial the documents containing the raw data, report, or chart produced by Ms. Chart. So I hope that makes sense, but if it doesn't make sense, essentially the Commonwealth is saying their DNA analyst, Tess Chart, she is medically unavailable for the retrial. So they are asking the Commonwealth, they're asking Judge Bev to allow Mr. Miyasako to replace Tess Chart. But Mr. Miyasako is not going to show, he's not going to talk. Okay, the prosecution is not going to show the raw data report or the chart produced by Tess Chart. I know it gets really confusing. It gets really confusing when Tess Chart is the DNA analyst and they are referring to a chart. But essentially, the prosecution wants to have Miyasako sit in Tess Chart's place during the retrial. And because the results and the work itself was conducted by Tess Chart, I don't think the prosecution would be permitted to show the raw data anyway, because it would be like having one expert opine about another expert's results. What you want is the expert who conducted the work. You want that expert to talk about their own work. You know, the prosecution would want Tess Chart to talk about her work pertaining to the raw data, the report, and the chart, you know? So it's like right here, they're covering their ass in a way by saying the Commonwealth does not intend to introduce at trial the documents containing the raw data report or chart produced by Ms. Chart. It's like they wouldn't be able to anyway because Mr. Miyasako did not conduct the work. So why would he be permitted to speculate, you know, to give his opinion about someone else's work, about Tess's work? Anyway, already it's like, just quit, you know, just, you can't have Tess Chart there, you know, and you don't have time to have Mr. Miyasako conduct his own test, you know, just give it up. Like it's a botched case anyway, just give it up. Continuing, it reads, in Williams versus Illinois, a plurality of 4 justices concluded that the introduction of a witness's opinion concerning a DNA, quote, match, end quote, did not violate the confrontation clause, where said opinion was based on a review of a DNA report from an out-of-state laboratory, and which was not introduced at trial. Furthermore, in Commonwealth versus Grainider, it's kind of cut off from the print, the Supreme Judicial Court held that Williams did not trigger a change in Massachusetts law that allows an expert to testify to his independent opinion, even if said opinion is based on data, not evidence. Furthermore, there was no violation of the defendant's confrontation rights where a DNA expert's opinion relied on DNA test results obtained by an analyst who did not testify. In the instant case, the Commonwealth is seeking to introduce the opinion of a witness who personally reviewed Ms. Chart's work and who will render his own independent opinion about the DNA results. For the above stated reasons, the Commonwealth's motion should be allowed. Respectfully submitted for the Commonwealth, Michael W. Morrissey. Oh, Michael Morrissey wants it, people. Hank Brennan, Adam Lally, and Laura McLaughlin, April 4th, 2025. So, short motion, guys, but again, it already reads a little convoluted, a little chaotic, and a little, even with this case law, it just seems like I feel like a majority of courts wouldn't allow this. They would want the expert who conducted the work. They would want that expert to testify about their own work, not another expert to testify about someone else's work, if that makes sense. So, and to further validate what I'm saying, let's look at what Andrea Burkhart has to say about this motion. She responded to it immediately. And she wrote, someone else took the screenshot. I don't know who took it. You know how screenshots travel around social media. It reads, "Oh, hey, I hear Bev has a thing about candor to the tribunal. How interesting that Brennan fails to mention the most recent authority on this issue, Smith versus Arizona, that specifically rejects the reasoning from Williams he's suggesting the court to use." So you guys remember, and it's funny she's saying Brennan, but again, guys, if we refer to the document, it's technically Michael Morrissey. It's technically the whole gang: Michael Morrissey, Hank Brennan, Adam Lally, and Laura McLaughlin. But I get where Andrea Burkhart's coming from. She's essentially saying it's Brennan, and the Williams. So again, referring back to the document, the prosecution is citing Williams versus Illinois. So Andrea Burkhart's response is saying, how interesting that Brennan fails to mention the most recent authority on this issue, Smith versus Arizona, that specifically rejects the reasoning from Williams he's suggesting the court use. And she includes screenshots of the Commonwealth's motion, the one we just read. And again, guys, it was from today, April 4th, 2025, just a couple hours ago. And then we're going to look at this one. Her post continues. In Smith, SCOTUS recognized that for one analyst to base conclusions on another's work necessarily requires a testifying analyst to assume the truth of the non-testifying analyst's work and reports. Yeah, like I was saying, guys, it just comes off as hearsay at that point. If you've got one expert on the stand talking about another expert's work, like, where's that expert? Oh, yeah, that expert medically can't come to the trial. Okay. So then have Mr. Miyasako, have him conduct the work that Tess Chart conducted. Oh, wait, it's too late because the retrial has to begin now. It's Judge Bev's trial. It has to begin right now. So then if there's no time to conduct more testing, then just give up, like, how about you just lose that portion? How about you can't talk about the DNA? Anyway, she continues, Andrea Burkhart continues, naturally, shepherdizing Williams shows that Smith rejected it. Lawyers in Massachusetts have a duty to inform themselves of the applicable law, see RPC 3.1, comment 2, and they may not fail to disclose known adverse authority under the candor rule. So it's kind of like in your face to the prosecution, and I guess in your face to Hank Brennan. At least that's Andrea Burkhart's target. um, and I'll try to read it here. It's a little blurry, but it reads: Our holding today follows from all this court has heard about the Confrontation Clause application to forensic evidence. A state may not introduce the testimonial out of state or out of court statements of I should just look it up myself. Anyway, I can't read it, guys. I apologize. Let's look at the next one. And she continues. So, Mr. Brennan has either failed in his duty to inform himself of the applicable law before asserting a position in court, or he has chosen not to disclose Smith to the court to advance a deceitful argument about the law. I wonder how gravely concerned the judge will be. Touche, Andrea Burkhart. Props to you. Good work. And guys, isn't this Hank Brennan? Doesn't this message, isn't Hank Brennan like all over this sentence? Or he has chosen not to disclose Smith to the court to advance a deceitful argument about the law. Like, is Hank Brennan, is he advancing a deceitful argument about the law? Is that like him? Or is it unlike him? Anyone paying attention to Hank Brennan's tactics? You know, good on Andrea Burkhart to call this out, to notice. Again, this sneaky prosecution, especially with Hank Brennan. You know, he's one of the most corrupt attorneys of our time. And as I've said before, he is ruthless with his misrepresentation of facts, his obfuscation of facts. You know, we all thought Adam Lally was pretty terrible, but Hank Brennan takes deceit to a whole other level. Yeah, he's a shyster. So anyway, let's read something else from Andrea Burkhart. And this was, I'm sharing this for you guys because the person who shared this article from Substack is from Andrea Burkhart's Substack. The person who sent it to me on Signal. So, Sue, thank you. If you're watching, thank you. And I welcome anyone else to message me on Signal. There is my screen name on Signal. It's analyze.01. So again, and that's also available on my YouTube homepage. So let's look at this one. Again, Sue, thank you for sending me this. And it's dated March 23rd, 2025. So just a few weeks ago. And it's titled, Can the Commonwealth Escape Ex-Trooper Proctor's Disgrace? Now that he's been terminated, here are some ways the Commonwealth could try to limit the damage. But chances are pretty good they're stuck with it. It reads, news landed this week that ex-trooper Michael Proctor of the infamous, quote, no nudes yet, end quote, texts in the Karen Read trial has been officially terminated by the Massachusetts State Police. 4 grounds are cited. 1, sending derogatory texts about Karen. 2, providing sensitive information about the investigation to outsiders. 3, creating an image that he was biased in his investigation. And 4, drinking on duty and then driving his patrol car. And I know I shared this before on my channel. So he was found guilty of all 4. And it reads, Trooper Proctor on various dates between January 29, 2022 and April 17, 2022 did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. And I will leave the link to this article in the description below. Continuing. Naturally, this is terrible news for the Commonwealth, who was already trying desperately to keep the misconduct of its investigators in the course of investigating Karen Read out of the upcoming trial. For sure. And Andrea Burkhart cites the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations, sustained findings unrelated to this case, or unfounded allegations of misconduct, right? And as I've argued before, guys, if the Commonwealth had a solid case, why would they be hiding so much? If the Commonwealth had a solid case, why is it that the defense is the only team here trying to bring the truth to light? You know, why has the Commonwealth, why has the prosecution so consistently attempted to hide the facts about this case? Continuing with the article, since this argument relies heavily on the conclusory and illogical, shall we say, together, ipse dixit. And for those of you who don't know, ipse dixit is Latin for, I think it's Latin for he himself said it. And it's basically an unsubstantiated claim that someone makes. Continuing. So, since this argument relies heavily on the assertion that investigators degrading a suspect during their investigation does not reflect any bias on their parts, the finding that ex-trooper Proctor's conduct, quote, created an image that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute, end quote, certainly tends to undermine this argument in the same way that an embarrassing faceplant tends to undermine a grand entrance. Good wording, Andrea. Continuing. This is so bad for the Commonwealth that they might even resort to the most drastic of measures to try to avoid it. Not calling ex-trooper Proctor, the lead investigator in the case against Karen Read, to testify. This is obviously going to look bad no matter what. But if it works at keeping out the fact that he was fired for misconduct for his behavior in the investigation, it might be worth it. So will it? Massachusetts puts limits on the ability of a party to impeach their own witness. The reason why the Commonwealth would try this desperate measure is because if the defense chose to call ex-trooper Proctor themselves, which they certainly can, they are under different restrictions when it comes to impeaching him than they are if they are cross-examining him. The restriction is both statutory and rule-based. And she provides Section 23, impeachment of party's own witness. The party who produces a witness shall not impeach his credit by evidence of bad character, but may contradict him by other evidence and may prove that he has made at other times statements inconsistent with his present testimony. But before proof of such inconsistent statements is given, the circumstances thereof sufficient to designate the particular occasion shall be mentioned to the witness. He shall be asked if he has made such statements, and if so, shall be allowed to explain them. Section 607, who may impeach a witness? Any party, including the party that called the witness, may attack the witness's credibility. However, the party who calls a witness may not impeach that witness by evidence of bad character, including reputation for untruthfulness or prior convictions. These restrictions would appear to prohibit the defense from impeaching ex-trooper Proctor with his termination and dishonorable discharge to show he is in fact dishonorable. So if the defense did try to call ex-trooper Proctor, I'd expect Mr. Brennan to try to limit his impeachment based on this limitation. The reasoning for the rule arises from concern for the integrity of the courts. At common law, the general idea was that by calling a witness, you were implicitly vouching for that witness's character and credibility. By impeaching the witness you called, you're basically establishing that you called somebody to the stand who shouldn't be believed, and as an officer of the court, you shouldn't be doing that. Because of this history, some jurisdictions still prohibit or limit parties from impeaching their own witnesses, while others, including the federal courts, reject this reasoning and freely allow it. A 1975 Massachusetts case, Walter versus Bonito, discusses this reasoning. And again, the article will be in the description below if you would like to read her citations. Continuing. But the problem the Commonwealth has is that evidence can be used for multiple purposes, and impeachment can be achieved in multiple ways. The admissibility of evidence always hinges on the purpose for which it's offered. And here, even if the termination makes ex-trooper Proctor look like a bad guy, it's also potential evidence to impeach him for bias. Criminal defendants have a constitutionally protected right to explore the bias of adverse witnesses. The right to examine adverse witnesses for bias is protected by the Sixth Amendment's Confrontation Clause. In Davis versus Alaska, the U.S. Supreme Court reversed a conviction where the defendant was precluded from asking a witness about his probation status, which could have influenced his statements to police because it resulted from a juvenile adjudication, which was confidential by law. All kinds of evidence that is not ordinarily admissible can be admissible if it is relevant to show a witness's bias. Citizen complaints against police prior incarceration, unadjudicated criminal charges, and history of prostitution have all been held by Massachusetts courts to be admissible to show bias despite being generally inadmissible for other purposes. So if you guys are paying attention what Andrea Burkhart is saying, that the defense may not be able to necessarily impeach Trooper Proctor because they were calling him as a witness. And certainly the prosecution is going to be on it, right, if the defense attempts to impeach Proctor. But Andrea Burkhart is saying the defense can still highlight Michael Proctor's bias, which could inadvertently impeach him to the jury, even if he can't technically be impeached by either the prosecution or the defense. Continuing. Thus, it is particularly notable in this case that one of the grounds cited by the Massachusetts State Police for terminating ex-trooper Proctor is conduct creating an appearance of bias in an investigation he led. Should he testify the way he did in the first trial, conceding that his texts about Karen were disgusting, but insisting they didn't affect the integrity of his investigation, it's going to be hard for that not to open the door to the fact that his own employers didn't agree. Really good point by Andrea. She's saying, despite whatever Michael Proctor said during the first trial, that he so-called regretted his actions and that it didn't affect the investigation, the integrity of the investigation. It's clear now to all of us paying attention to this case that the fact that Michael Proctor was terminated by the Massachusetts State Police, from the Massachusetts State Police, means they did not agree with him. They do not have his back. They don't agree with him. They don't agree with what he said during the first trial. Otherwise, why would they have terminated him? And again, they cited 4 reasons for his termination. Continuing, they fired him for his misconduct in part because it made the investigation look biased and brought the agency into disrepute. Because of the constitutional magnitude of the right to examine witnesses for bias, It would be risky indeed for Judge Cannoni to preclude the defense from eliciting that ex-trooper Proctor was terminated in part due to the appearance of bias of his investigation of Karen Reed. Should she so rule, add this one to the list of appellate issues should Karen be convicted. Great work. So what Andrea Burkhart is saying is that because the ability to show a witness's bias on the stand is constitutionally protected, if Judge Bev and the prosecution insist anyway, if they try to object or sustain objections that the defense can't point out Michael Proctor's bias, that is a constitutional violation. And it could be added to the list if Karen Reed wants to appeal whatever happens at the conclusion of the retrial. Continuing. Bottom line, it's highly likely to come in. Ex-trooper Proctor's bias against Karen is a material issue in the case, central to her Bowden defense that law enforcement failed to adequately investigate alternative leads, and highly relevant to his credibility as one of the officers alleged to be at the center of the framing of Karen Reed. This ruling by the MSP could not have come at a more inopportune time for the Commonwealth, because it undermines ex-trooper Proctor's insistence that just because he acted like a scumbag towards Karen and admitted the homeowner would not get any, quote, shit, end quote, because he's, quote, a Boston cop too, end quote, his investigation was thorough and unbiased. Not even your boss's buy it, dude. Great work from Andrea. And guys, remember that. Remember those text communications, those messages that Michael Proctor sent and that were revealed during the first trial. Remember how Michael Proctor told on himself with those messages that because Brian Albert owned 34 Fairview, and because at the time Brian Albert was a Boston police officer, he was actually in charge of a department, I forget which one, in the Boston Police Department. Michael Proctor was like, nothing's going to happen to him. Nothing's going to happen to Brian Albert. Nothing's going to happen to the homeowner of 34 Fairview, even though John O'Keefe was found outside and on his front lawn, beat to death and suffering from hypothermia. Like Michael Proctor, before even conducting an investigation, already made up his mind that nothing was going to happen to Brian Albert. And why? Because he's a cop too. Continuing. Flail as the Commonwealth might to try to avoid ex-trooper Proctor's disgrace, he's boxed in by the poor decisions he made at the opening of the game. His own lack of judgment set the trap he finds himself in, and he's run out of moves to avoid springing it on himself. Great work, attorney Andrea Burkhart. She is a badass. And again, thank you, Sue, for sending this to me on Signal. And as always, guys, I will leave the links to everything in the description below for your viewing convenience. Thank you so much for watching.